Derek Chauvin trial, we now have the government resting their case. The defense attorneys have rested their case. And so the attorneys, the judge, the prosecutor, everybody involved, they're now sitting around in court. They're hashing out what are called jury instructions. And so we want to flesh out what those are and what this means for the Chauvin trial, because it feels like we're kind of missing something. It's Friday. There's no trial. Nobody's watching anything. What the heck is going on? We're going to break that down. And as is always the case, let's start by taking a look at the trial board so we can get our bearings straight. We know that yesterday, Eric Nelson and the defense rested their case. We know that a couple days before that, we had the prosecution rest their case. We are not going to be hearing from Maurice Hall at all in this trial, so that's done and closed. And so now we have no more evidence to be presented. And so on Monday, what's going to happen is the prosecution is going to offer their closing arguments to the jury panel. Then the defense is going to offer their closing arguments to the jury panel. And then we're going to be left with these jurors. The jurors are going to decide what the outcome is. They're going to deliberate, and we're going to get a verdict. And so if you have not been following the channel for some time, if you kind of joined us after jury selection started, these are the emojis that we have selected for the jurors, and they are actually representative of the jurors who are on the panel. And if you don't remember, but this is what we went through. This is our juror chart. So this is who we're going to be sort of presenting closing arguments to. Both sides, the government, the prosecution, and the defense are going to be communicating to these people. We've got, as you can see here, we've got white, multiracial, white, black, multiracial, white, black, white. We've got a whole range of different ages, all the way from 20s, it looks like, up to 60s. We have chemists, auditors, bankers, fathers, consultants, nurses, people who are retired, social workers. We have some people who support BLMs, people who say all lives matter. We have somebody who had an uncle in law enforcement. We have somebody who said no to defunding the police. Somebody's married with a son, right? We've got a lot of people that we're communicating to. And so they're crafting their arguments, and they're also crafting the instructions that these jurors are going to use. They're not just going to throw them in a room and say, here you go, do whatever you got to do. You know, what happened with the guilty or not? You guys go in there, decide. We're going to order some pizza, some Mountain Dew. You guys hash it out. Let us know when you've resolved it, right? It's going to be a little bit more organized than that. They're going to have a set of instructions that they follow. They're called jury instructions. And why do we need this? Because there's a lot of information in this case. They got to organize it all and make sense of it. They've got all of these witnesses from the government, and this is not even the full set. They've got all of these witnesses from the defense. And so they've got to sort of make sense on how to organize this stuff and how to apply all of the facts that they heard, all of the opinions, expert witnesses, body cam footage. We saw slides out the wazoo. And it's just been an overwhelming fire hose of information for them. And so they need some guidance on how to sort it all out. And so what happens in a criminal case like this is both sides will submit what are called proposed jury instructions. And this is what they look like. So you'll notice that down here we have the state's proposed jury instructions over here on the right. So this is what the government is sending in. Then we have the defendant's proposed jury instructions. And we're not going to go through both of these, all right? Both of these were submitted on February 8th, which is before the trial even started. And so these are sort of the first draft, we'll say, of what they want submitted. And the way that this typically works is, at least in Arizona, we have what are called Rajis. They're Arizona's version of jury instructions. And so these are sort of templates that exist, right? You know what aggravated assault is by statute under the law, or you know what a DUI is. Let's use DUI. Everybody knows what that is. So you've got a DUI charge, and you say, well, we know what the law says about it, but what are the jury instructions? And so what the courts and attorneys have done over the years is they've created a bunch of templates. And so attorneys will start with the templates and then make modifications based on what they think is appropriate given the facts of their case. So that's happening right now. So in Minnesota, I think they call them CrimJigs, criminal jury instruction guidelines or something like that. And they have their own little acronym for them. And so what is happening is those are the starting point, and then both sides want to modify them. So that's what we're looking at here. We have the state taking those templates and modifying them, and we have the defense doing the same thing. We're not going to go through them all, right? Because they're very one-sided. What you're going to see is the defense is saying that we want to communicate everything in a way that makes Derek Chauvin look innocent as possibly can be. They're talking about, they think there should be instructions about officers' use of force and how officers are supposed to analyze a scene and why that's relevant, that the jury knows that they should be focused on the totality of the circumstances. And so they want to sort of wiggle in a lot of useful language that's going to be helpful for Chauvin. Conversely, government's trying to do the exact opposite of that. So both of these are pretty one-sided. They're going to flesh it out with the courts, and they're going to move towards the middle. The judge is ultimately going to dictate what gets sent over to the jury panel. But I wanted to show a couple quick things on this. So number one, I want to quickly point out that this is something that was submitted out of the 4th Judicial District. Okay, so Chauvin's case is out of the 4th Judicial District, also out of the county of Hennepin County, right? Also out of Minnesota. So we're in a jurisdiction, we know where we're at. And so because I don't want to go through the state's jury instructions and the defense jury instructions because they're both just totally biased, let's look at another case that had jury instructions that was in fact used, that is a very similar case to Derek Chauvin's case. So we can just sort of say, okay, so this is what they settled on, very similar charges. We can basically say, all right, well, it's the same court, it's the same judicial district, it's the same state. We're probably going to be seeing something very similar to this older case. So we're going to take a look at this. It's called Mohamed Noor, and this is what it looks like. So I don't know exactly what the jurors are going to be getting, but you can see this, right? This is Judge Catherine Quantaince presiding. She's running this, and this is a packet, it looks like, that the jury got, and it's a set of jury instructions. And so you'll notice here, right, 4th Judicial District, same court, same county, same state. This was filed back on 2019, so it's not even that old. It's the same court. It's the same jurisdiction. So we can expect that what we're going to see here is going to be very similar to what we're going to see in the Chauvin trial. So that's why we're going to go through it. We're not going to go through the whole thing. We're going to take a look at the pertinent parts, but I want to flesh this out, frame and flesh this out. I was trying to spit out those two words at the same time. So I want to frame this out a little bit so that we can understand what's happening. Now, I don't know how this is working, practically speaking, in court. So this may have been a binder that, or a printed packet that was shoved in a binder, and you have a big binder with all your notebooks and everything you've been working on. But the judge yesterday, Judge Cahill, was talking about a laptop. And so I think that they're going to get laptops, all of them individually, so that they don't have to come back into the courtroom. Traditionally, you kind of send the jurors out to the deliberation room. If they want to watch video or other evidence, they come back into the courtroom. But the judge, it sounds like, is trying to make this a little bit easier with all the COVID precautions and on and on and on. So you're all going to get laptops. You all get everything. So something like this may be on their computer, but this is the manual, right? They heard a lot of evidence. This is what they're going to be looking at. These are your instructions. So anytime you have a question, well, what does that word mean? What does this word mean? You go back to your jury instructions. And so that's what we're trying to frame out, because people have had a lot of questions. Well, what do they have to prove? What does this mean? What about this element? What about excessive force, reasonable force, objective reasonableness? What does asphyxia mean? And all of these different permutations supposed to be answered, or we get at least some guidance from the jury instructions. So we're going to spend some time on the Noor case, and it is actually a very interesting case, very similar to what happened in the Chauvin situation. So let's take a look at what happened here. We can go over to Wikipedia for a quick summation. This is the woman who was shot and killed. So her name is Justine Damond, and this also took place right there near where George Floyd was killed. So we have Minneapolis, Minnesota. On the night of the shooting, this woman, Damond, called 911 at 11:30 at night, again at 11:35. She reported that she thought she heard a woman either having sex or being raped. Dispatchers, so this is just a woman, just calls the police. Dispatchers categorized the call as unknown trouble, female screaming, relatively low priority. Officers Noor is the person who got charged with the crime here, and Harity, they responded to Fulton, which is a low crime neighborhood. They drove their Ford Explorer with lights off through the alley, found no suspects, no signs of rape, nothing that had prompted Damond's calls. Officers prepared to leave. Noor entered code 4 into the cruiser's computer, meaning the scene was safe. Harity would later indicate that he was startled by a loud sound near the squad. And then, just then, Damond approached the car, the driver's side window. Harity drew his weapon but pointed it down and did not fire. Noor, however, fired once through the open window, fatally striking an unarmed and barefoot Damond in the abdomen. So she got shot right in the abs. The officer attempted CPR, no avail. She died 20 minutes later. Harity later told the supervisor, "We both got spooked." So Officer Noor, of course, got charged with the crime. Harity testified of hearing something that hit the car, and I also hear some sort of murmur. And then he said that he feared an ambush, but deemed it premature to use deadly force. Noor testified that he did not see Damon's hand or any object in it, but nonetheless believed that his partner feared for his life and there was a threat. Prosecutors presented evidence that Damond's fingerprints were not on the police car, meaning that she never touched it, called 2 expert witnesses on police use of force who testified that Noor's decision to shoot was unreasonable. So it kind of sounds like some of the same testimony that we heard in the Chauvin case, doesn't it? Both officers had their body cameras switched off, of course. Minneapolis introduced body cameras in 2016, but their activation was not mandatory in all situations. So no audio or video recordings captured the killing, although a 16-year-old bicyclist took cell phone video of the scene after the fact, right? So the reason why I wanted to go through this is not to necessarily... they're obviously different cases, but we have a police officer who's being charged with murder charges and manslaughter charges for shooting somebody and killing them, essentially. Very similar. Chauvin's also being charged with those charges for killing somebody. And so it's a very similar set of circumstances. And as we're going to see, very similar charges. I think they both got charged with 3 different charges. 2 of the 3 are the same in both cases. So then this case went to trial on March 20th, 2018. He was charged with second-degree manslaughter, third-degree murder, but claimed self-defense. Prosecutors upgraded those charges to second-degree intentional murder. So that's the charge that we do not have here, right? We have a second-degree unintentional felony murder charge. This is the charge that is not the same, so we're not going to look at that one. In April 2019, Noor was convicted of third-degree murder and manslaughter, which are 2 charges that we're looking at in Chauvin's case, but acquitted the intentional second-degree murder. So people are asking, well, how does this play out? How does this shake out before? Maybe it might be like that. In June 2019, he was sentenced to 12 and a half years in prison. Family brought civil suit. They only got $20 million instead of the 27 that Floyd's family got. So they got a little bit lower of a settlement. So now that we have some backdrop on the Noor case, we know officer shot somebody, killed them, know that they were charged with third-degree murder, manslaughter, second-degree murder. Very similar charges to Chauvin, very similar situation. He also is being charged with crimes for killing somebody for same issues, excessive force, and on and on and on. So now that we know what the background looks like, let's take a look at the instruction. So in this case, same county, same court, same cities, different judge, but the same whole backdrop as Chauvin. This is what the jurors get. And I want to just run through this briefly, but you're going to see here, this is the first page. It says duties of judge and jury. As soon as they open that up, they're going to see, it is your duty to decide the questions of fact in this case. It is my duty to give you the rules of law that you must apply in arriving at your verdict. So remember, the jurors don't get to manipulate the law a little bit. They don't get to come out and say, well, I don't think that is how it should be. No, that's not how that works. They have to decide what the facts are and apply the law to those facts. And this says, you must follow the rules, apply the rules as I give them to you, even if you believe the law should be different. Deciding questions of fact is your exclusive responsibility. In doing so, you must consider all the evidence you have heard and seen in the trial, must disregard anything you may have heard or seen elsewhere. I have not by these instructions, nor by any ruling or expression during the trial, intended to indicate my opinion regarding the facts or outcomes of this case. If I have, disregard it. And then they talk about this presumption of innocence. And so you see what's happening. They're going to insert the defendant's name. And they're going to make it specific to the defendant, right? So this is not just like a general boilerplate list of instructions. They're going to actually go in there. Right here we have Mohamed Noor, but we're going to put Chauvin's name in there, right? And actually this sounds like it's a little bit different than even what the judge read yesterday. Judge Cahill, if you recall, during yesterday's show, specifically was asking Derek Chauvin about this. Said, hey, look, I want to make sure you're very clear. You're not going to testify. You have a right not to, but you also have a right to come in and testify if you'd like. And was very clear in sort of an admonishment just to make sure he's well aware of what he is giving up if he does not testify. And then Judge Cahill read through what he's going to read to the jury, and it sort of sounded like this, but not quite. Defendant Mohamed Noor is presumed innocent of the charges made, right? It's a presumption of innocence. So the jury is going to be looking at this. Second paragraph, probably, right? This is an example. Presumption remains with the defendant unless and until he has been proven guilty beyond a reasonable doubt. That he has been brought before the court by the ordinary process of the law and is on trial should not be considered by you in any way as suggesting guilt. Burden of proof is on the state. Then we get the burden of proof beyond a reasonable doubt standard, right? Very, very big standard. Beyond a reasonable doubt does not require that the elements be proved beyond all possibility of doubt. Proof beyond a reasonable doubt is the amount of proof that ordinary men and women would act upon in their most important decisions. You have a reasonable doubt if your doubts are based upon reason and common sense. Okay, I say that a lot on the show. If you have doubt and it's based in reason, that's reasonable doubt. That means your doubt is pretty reasonable. It's based on reason and common sense. You do not have a reasonable doubt if your doubts are based on speculation or irrelevant details. Very, very critically important explanation right there, right? This is what defense attorneys lean on all day. Hey, you've got some doubts about this, right? And so we're probably going to see language that looks just like that. Direct and circumstantial evidence, right? So we talk about this a lot, sort of the difference between seeing snow on the ground. If you are outside and you're watching snow come from the sky and hit the ground, that's direct evidence. You saw it happen directly in front of you. But if you're inside and you have dinner, you go outside to gaze at the stars with your lovely significant other. Wow, it's beautiful, honey. Don't you think? Yes, sweetheart. And there's no snow coming out anywhere, nothing hitting the ground. You go to bed, you wake up the next morning, you're having breakfast, you go outside, there's snow on the ground. Oh my gosh, how did it get there? Well, circumstantial evidence says, well, we can sort of presume that it fell out of the sky and come to a reasonable conclusion on that. That's kind of how we use the analogy we use to distinguish between the two. So circumstantial evidence, yeah, you can kind of fill in the gaps a little bit. You weren't out there seeing the snow hit the ground, but you woke up and there's snow on the ground. Presumably it snowed. So you can make an inference like that. But you could also, right, somebody could have come and shoveled snow out of their back of their pickup truck or something like that. Probably unreasonable, probably very unlikely, but you could attack circumstantial evidence in that way. Typically doesn't work out well for you. But that's the point, right? This is direct versus circumstantial evidence. So there's a paragraph that they give us on that. Rulings on objections to evidence. During this trial, I have ruled on objections. You must not concern yourself with the reasons since they are controlled by the rules of evidence, right? Goes on. Then we're going to see a little bit more about what to do with certain people who have come into court. So instructions, you got to look at these things as a whole. Notes taken by jurors. Yeah, you've been allowed to take notes. You're allowed to use these, but your notes are not binding. They're not conclusive. They're your notes. They should be used as an aid to your memory, not as a substitute for it. It is your recollection of the evidence that should control. You should disregard anything contrary to your recollection that may appear in your own notes. All right, so this might change. It might stay the same. We have statements of judges and attorneys. Attorneys are officers of the court. It's their duty to make objections they think are proper and argue their case. However, they're not evidence. If they or I as a judge have made any statements as to what evidence is and differs from your recollection, disregard our statements. Focus only on the evidence. Then we see that there is some evaluation of testimony about the believability of the witnesses, right? So in this case, critically important. We've got a number of different expert witnesses who many people will say they're kind of disagreeing with each other. You have Dr. Baker, who is a medical examiner, kind of disagreeing with Dr. Chauvin about Floyd's cause of death. You've got the law professor who is disagreeing with Sergeant Steiger, who is the use of force expert from the LAPD, about the prone position. You've got some disagreements on these things. That's just on the government side. And then you bring in the defense expert witnesses, and they're also in total disagreement. You had Dr. Fowler, who came out, the defense last witness, who came out and said that, basically Floyd could have died from carbon monoxide poisoning, amongst other things. So what's the jury going to do? Who do they believe? How do they sort all this out? Because he sounded pretty smart. He sounded pretty smart, and they're in disagreement. Who am I to believe? Well, we have instructions for that. This is what it says. You are the sole judges of whether a witness is to be believed and of the weight to be given that testimony. There are no hard and fast rules to guide you. In determining believability and weight of testimony, you may take into consideration the following: their interest or lack of interest in the outcome of the case. Oh, right. We saw a lot of expert witnesses came in and they were testifying for free, very interested, watching every word, calling them up. The witness's relationship to the party, the ability and the opportunity to know, remember, and relate to the facts, the witness's manner, their age, their experience, their frankness, their sincerity or lack thereof, the reasonableness or unreasonableness of the witness's testimony in light of all the other evidence in the case, right? Are you scrolling back through all the witnesses that you heard going, oh yeah, that's a problem for that witness, or that's a problem for that witness, because that's exactly what I'm doing. We have any impeachment of the witness's testimony, so cross-examination, any other factors that bear on believability and the weight. You should rely in the last analysis upon your own experience, good judgment, and once again, common sense. So you get a little bit of a framework there on how to analyze this. Now that's for lay witnesses. For expert witnesses, we have a couple additional factors. A witness who has special training, education, experience, and so on. You can also consider their training, experience, knowledge, the reasons given for their opinion, their sources of information. We saw a lot of books being held up, particularly by Mr. Blackwell. Factors already given for evaluating the testimony of any witness. We have impeachment. Okay, this is sort of during cross-examination. If they come out and go after one particular witness. Those are some guidelines on how impeachment works. We have the defendant's right not to testify. Okay, so maybe this is what we were hearing Judge Cahill read yesterday. The state must convince you beyond evidence, beyond a reasonable doubt, that defendant, we'll put in Derek Chauvin here, is guilty of the crime charged. He has no obligation to prove innocence. The defendant has a right not to testify. The right is guaranteed by federal and state constitutions. I think that Judge Cahill's soliloquy was a little bit different. Multiple offenses are considered separately, instruction on demonstrative evidence generally. And so this is all procedural stuff. Let's get into the meat. This is the good stuff. Now, what does murder in the third degree mean? This is one of the charges that Derek Chauvin got. It's one of the same charges that Mohamed Noor got. Here's what it looks like in the jury instructions. You can see here it says murder in the third degree, depraved mind. So Derek Chauvin, who's being represented by Eric Nelson, is facing this. And here's how the jury is going to be explained this instruction. Under Minnesota law, a person causing death of another by perpetrating an act imminently dangerous to others and evincing a depraved mind without regard for human life, but without intent to cause the death of any person is guilty of murder in the third degree. This is the depraved mind murder, right? And we've seen this language already in Chauvin's case. Depraved mind, eminently dangerous. It's in his charging documents because he's been charged with the same thing. The elements of murder in the third degree are alleged as follows. So this is what they would put in there. First, death of Justine Rusiek must be proven, which is a different name than Demond. Maybe that was a different, okay, whatever. But here it is. So we got to prove causation. Second, Noor caused the death. So we got to have causation, right? We're spending a lot of time fighting about this in the Floyd case. Third, and this is where you're going to see some of the language, right? So let's think about this in context of Chauvin and Floyd. Third, the defendant, Mohamed Noor's intentional act, which caused the death of Justine, was eminently dangerous to human beings and was performed without regard for human life. Okay, so you can just swap those out. Let's do it. The defendant, Derek Chauvin's intentional act, which caused the death of George Floyd, was eminently dangerous to human beings and was performed without regard for human life. See how that fits? Such an act may not be specifically intended to cause death, may not be specifically directed at the particular person whose death occurred, but it is committed in a reckless or wanton manner with the knowledge that someone may be killed and with a heedless disregard of that happening. So you see how that's a little bit different, right? This is an explanation of this. They're saying, well, what is this? What does imminently dangerous mean, right? That's kind of confusing. What is that? Well, this is what it means. It was an intentional act performed without regard for human life. It was reckless, done in a reckless or wanton manner with the knowledge that somebody may die. So the jury's going to ask themselves about that. Does that apply to Chauvin? Next, they're going to ask, where did this take place? Did it happen on this date in Hennepin County? Sure it did. Easy. If you find that each of these elements has been proven beyond a reasonable doubt, he's guilty of the charge. If you find that any element, any one of these, first, second, third, any of those are off, he's not guilty of this charge. Okay, so that's the third degree murder charge. Let's take a look at the next one. This is the manslaughter in the second degree charge. Here it is. And this is also what Derek Chauvin is being charged with. Right? And you may notice, recognize this language. Under Minnesota law, whoever, by culpable negligence, which is what we've seen in Chauvin's case, he's charged with the same crime, whereby he creates an unreasonable risk and consciously takes the chance of causing death or great bodily harm to another person, causes the death of another, he's guilty of manslaughter in the second degree. So we've got culpable negligence. We see that, right? So this is the law. This is the explanation of the law down here. So we have culpable negligence. That's defined right here. We have to cause. That's defined cause, right? What does causing mean? We're going to have a lot of questions about that in Chauvin's case. So let's see how this breaks down. First, the death of the Justine must be proven. Easy. Floyd must be proven. Got that. Second, the defendant, Mohamed Noor, caused the death by culpable negligence, whereby they created an unreasonable risk and consciously took a chance of causing death or great bodily harm. All right, so now what? And it's complicated. Let's break it down. To cause means a substantial causal factor in causing the death, right? A substantial causal factor. So how do we decide what that means? The defendant, Mohamed Noor, is criminally liable for all consequences of his actions that occur in ordinary and natural course of events, including those consequences brought about by one or more intervening causes. if those intervening causes were the natural result of his acts. The fact that other causes contribute to the death does not relieve the defendant of criminal liability, right? So that version of the jury instructions, that may sound bad, right, for Chauvin. So what if Floyd had a heart problem? So what if Floyd took drugs? So what if any of those other things came into play? Doesn't matter. He's responsible for that as a consequence of his action. So that's causation on that charge. But the causation has to be brought about by culpable negligence. Got to be doing something off, right? You can't, if he was acting within the purview of his duties and Floyd died, that would just be, right, a death. That would be a homicide, but no criminal intent or criminal liability connected with that. So now we got to look at the second part of the statute, which is culpable negligence. What does that mean? It is intentional conduct that the defendant, in this case Noor, may not have intended to be harmful, but that an ordinary and reasonably prudent person would recognize as involving a strong probability of injury to others. Ooh, see, we got a lot of debate about that. A lot of experts who say, yeah, what Chauvin did easily has a strong probability of injury. Got some other people on the defense who say otherwise. Culpable negligence is more than ordinary negligence. It is more than gross negligence. It is gross negligence coupled with an element of recklessness. Oh, great. Well, then what the heck does recklessness mean? So recklessness now is a conscious disregard of a substantial and unjustifiable risk of death or great bodily harm to others. So it's basically saying under these instructions that Chauvin must have created a risk, known that that risk was substantial, that there was no reason for taking the risk, and that Mohamed Noor, or in this case Chauvin, was aware of the risk, and that the defendant disregarded it. He need not have intended, however, to cause harm. So you see how complicated this gets? Then we have great bodily harm, means bodily injury, which creates a high probability of death. We got to debate about that, right? What was a high probability of death? We've got disagreements about that particular issue from multiple witnesses. Third, they're saying it happened within Hennepin County. If you find that each one of these has been proven beyond a reasonable doubt, then he is guilty. But if it's not, then he is not guilty. These are the instructions. This is literally the document, something very similar to this that the jury is going to be looking through. You can see you've got a lot of different rules that are playing with one another. You've got causation. You've got culpable negligence. Well, what does negligence mean? Well, it's more than gross negligence. It's more than regular negligence. It's recklessness. All right, well, what does recklessness mean? All right, what's a new set of rules? So it's very important. That's what these attorneys are in there going word by word, going, nope, don't like that, don't like this. We're going to argue over this sentence, argue over that sentence. And the judge is just flushing it out with them right down the middle. So this is how it ends up. We're going to skip a lot of the document, obviously, but this is it. It says duties of jurors. When you return to the jury room to discuss this case, you must select a jury member to be the foreperson. They're going to lead your deliberations. In order for you to return a verdict, the verdict must be unanimous. You should discuss with one another, deliberate, decide the case for yourself only after you've discussed it with your fellow jurors. Do not hesitate to re-examine your views. Change your opinion if you're convinced they're disagreeable. Foreperson must sign and date the forms. You're going to be given 3 verdict forms. You're going to return to the courtroom. In arriving to your verdicts, the subject of penalty or punishment is not to be discussed or considered by you. That only lies with the court. You only have to decide whether the charges are proven beyond a reasonable doubt. You've got a duty to the state. You've got a duty to everything. Get over your personal prejudices and biases. Now the case is in your hands. Ooh, that is a tall order. So they're going to be sequestered when they go into that. So we're going to have closing arguments on Monday. Probably have some jury instructions fleshed out by the both sides on that day or very shortly thereafter. And then the jury, we should have a Monday because as soon as they finish closings, they're going to hand it off to the jurors. They're going to be sequestered. We're going to get a verdict. Who knows how long that is going to take, but it's going to be interesting, and we're going to be live streaming that whenever that happens. Whenever they're going to be reading the verdict, we're going to be going live. So be ready for it. It's going to be an interesting week. All right, so let's take some questions over from our tremendous community at watchingthewatchers.locals.com. First one of the day comes from LT13. It says, do you think the chemist will have an advantage to all the gases that was presented? I was wondering if they get to look up anything to translate the expert witnesses, and if they don't, that chemist might be valuable. Yeah, so the judge isn't going to let them go and look stuff up or like get on the internet and, poke around. But if they do have questions, then they can present those to the judge, and the judge can present those to the attorneys. And if certain witnesses are available, they try to flesh out some of those questions. We're probably going to see a lot of jury questions, and everybody who is observing trials, they're all just like waiting, because every time a juror comes out, it's like, hey, can I use the bathroom? And everybody goes, oh, that means it's going to be a not guilty. That juror number 14 had to go urinate. Oh, everybody freaks out about every little thing that happens. So I'm looking forward to that. It's a lot of fun. Can't wait to join in. We have Maddie Jones next in the house. Says, do we know who the foreman is for this trial? No, we do not. Will we ever know? Probably. If I had to bet, I would say it is the 50s white female executive assistant. She seemed to have a very authoritative presence during jury selection. In your opinion, how much influence does the foreman have in the deliberation room? So it depends. I mean, it really just depends. It can be the foreperson. It can be really any strong personality. And so, that's something that you are looking for during jury selection, those strong personality people. And you want to figure out what to do with them, right? There are different jury selection strategies where some attorneys just only look for that one person, right? They don't even care about any of the jurors. They're looking to headhunt the one who's going to be that standout juror. Some defense attorneys do that, right? You don't need to convince all the jurors, just got to get one so that they don't have a unanimous conviction. So, it can be that. It can be that you have a foreperson who's very aggressive. You can have a foreperson who gets voted because they have some sort of seniority, but then they don't really, they sort of fold under the leadership task and somebody else kind of commandeers it. It's a strange thing. It's one of those things that I don't really know how useful it is. There are a lot of consultants out there, a lot of people who try to really reverse engineer stuff. But I mean, I've had conversations with people just in law, or I would think for sure that one person was going to give me an answer based on all of my analysis, right? This person's a mom, she's 50, she's got blonde hair, she carries that type of bag, she showed up in that car, whatever. So clearly, this is who I think she is. Totally opposite, not even remotely close, right? Like an answer out of left field that nobody would have ever guessed. And you're going, well, what the hell did I waste all that time like learning all this stuff for? Is it even relevant? So I'm kind of in that camp. I know it is important, and I know there's a lot of consultants and jury people who will sort of obsess over jury selection, but I just never have really... There's only so much that you can understand about a person and sort of inquire about before you're giving yourself sort of a sense of fake confidence, whatever that concept is. John Delar, 52 in the house, says, if the makeup of the jury is so important to final verdict, why don't we have professional jurors who are completely vetted and tested so that we don't have to worry about bias? Well, because we are supposed to have that's a good question. Or like, why don't we like create AI systems or something, right? That just like solve this stuff for us because humans are biased. Well, it's because the law says we got to have a jury of our peers. And so we take an even cross section of our peers throughout society, and I think it works out. But it's a good question, right? And maybe in the future, maybe in our crypto country, we have blockchain verdicts. We have, who's next? We got Osak. Rob, big fan. So do you think the prosecution will go at this again if there's a hung jury? Absolutely, yeah. Yeah, if they don't get a verdict, they're going to go back. They're going to, yes, absolutely yes. They have a very, 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 very strong motivation to carry this thing forward. And for good reason, right? A lot of people in the country want to see this resolved. We have C. Mills in the house. Can they push through the third murder 3 when they can't prove that he knew it would result in death? To my knowledge, no one has died from that restraint posture while in custody until now. Yes. So it's a good question. Yeah, it's a really good question. And so I'd have to go, I would want to compare that with the statute. Like I would want to reread the statute again. And I don't know that I can do that right now in my slides. No, I can't. So I would want to read it again because it did have some very specific language in that jury instructions about whether they knew. And I just can't recall right off the top of my head what the instructions say. We are going to see what the instructions say about any of that, right? And I think it's probably going to default back to the objective reasonableness standard and whether or not the officer, an officer in that position would have done what he did in the way that he did it. So it's not necessarily about the prone position, exclusively the prone position. It's about the prone position and the handcuffs for 9 minutes. It's about that. And so I think that when they narrow down that instruction, it's going to reflect language that is sort of neutral on that. It's not going to be dispositive one way or the other on that issue. Good question, though. Honestly Rational says, how do you feel about charging someone with both murder and manslaughter? It doesn't seem right to me that prosecutors can argue for both charges in the same case if they both have to prove something beyond a reasonable doubt. To me, both charges make me doubt that they're sure about what he's guilty of. Yeah, so I think the sort of complaint that you're bringing up is sort of like this concept of like double charging, where the prosecution will say, well, somebody died, so we're gonna charge you with a bunch of different crimes that relate to somebody dying. If we can't get murder, it's fine, we're gonna get manslaughter, right? And kind of work their way down. Very common in the law. It's not even something that is an issue, right? This happens all the time. And they do this a lot in DUI cases. So they'll take a DUI case and they'll say, well, this person's blood alcohol content was a 0.21, let's say. The cutoff is a 0.2 for a super extreme charge in Arizona. Or let's say it's let's stick with that. So it's a 0.20. This person comes back with a BAC of 0.21. Very high. Super extreme DUI, highest category that we've got here. But they're not just going to charge that person with that one count, a super extreme. They're also going to charge them with all of the lower tiers. So it'll be yes, if you're over 0.20 BAC, you're also over 0.15, which is the next tier down, which is an extreme DUI. You're also above a 0.08, which is the regular DUI. You're also impaired to the slightest degree. So we're going to charge you with a super extreme. We're also going to charge you with the other underlying charges so that if we lose the super, because you're close to the margin, right? What if you hire a good attorney and they come in and they say that 0.21 could be as low as a 0.19, which is under the 0.20 threshold. Well, now, if they only charge you with the super extreme, they're going to lose their entire case. So they'll just say, well, we're going to lose the top charge and we're going to win the others. And that's common in our prosecution. And that's what's happening here, right? I mean, he's charged with murder and the elements are different enough that that constitutionally that is permissible, right? You couldn't charge him with two of the exact murder charges because it's the same charge, right? That's double jeopardy. You can't be twice charged for the same crime. But here, they're slightly different and they're on degrees of intent. So on the murder charge, it's intent to commit the felony, which resulted in the death. On the manslaughter charges, it's culpable negligence. So we have different standards which allow, according to our Supreme Court, for both charges to be brought in the same case. Good question. Wow. We have Ian Fromm says, I understand that Chauvin absolutely has the right not to testify under the law. My question is, was it necessary for him to take the Fifth to avoid testifying, or could Nelson have just decided to close without calling him? So I think like in regular trials, you just don't call your defendant, right? No, you're not going to call him, right? Nobody makes a big deal about it. It's like commonplace, right? You set your case to trial. Most trials are kind of routine, right? It's kind of just, all right, we'll set this one, fill out some forms. These are our witnesses, kind of basic stuff. This is obviously so highly scrutinized that they are making sure that everything is done as formulaically as possible. I mean, we're going overkill on the formalness of this entire thing. And so, yes, they were very deliberate with Derek Chauvin about ensuring that he knew what he was doing. He was giving it up because the judge, for the judges and the court's own protection, doesn't want this to come back down on appeal later, right? Chauvin, 14 days from now says, you know what? I really should have testified. The judge didn't tell me that I could. I disagreed with my lawyer. My lawyer said I shouldn't, but I really wanted to. And so now I'm going to appeal this. The judge, nope, can't do that, buddy. I asked you point blank like 3 separate times, and you confirmed on the record, on a recorded line and video that we have documented for all eternity. So that basis is an invalid appeal. So I think that's kind of what you're seeing take place. Be Brave says, when it comes to closing arguments, do the attorneys have to be honest in their statements? Yeah, they do, and there are a lot of rules about this, right? So the attorneys can't just start making stuff up like throwing out, it's called facts not in evidence, right? So if they introduced a new theory in their closing argument, they're going to get objections all day. So they have to sort of follow the same theme. It's really like a summation of the evidence with some, compelling argument. You may see some more policy conversation in there, but really what I think you're going to see both sides do is just kind of summarize the evidence that you heard and then compare and contrast and show communicate why their argument was more effective than the other side. But yeah, they have to be honest. They can't come out here and say, whatever they want. It's not a free for all. There are some pretty hard rules that they got to stick to. Ma Fox says, lots of people are curious if attorneys can lie to the court or perhaps perform lies of omission. Care to help them out? Bar ethical standards, etc. Yeah. So hopefully I kind of answered some of that question on the last comment. But yeah, I mean, attorneys, you have a duty of candor to the court. You've got a duty of, you have to be have to have integrity when dealing with the court. If you are, manipulating evidence or you're, adjusting things around the margin, then that is a serious problem. And, you sort of saw that yesterday with in the Chauvin trial, because Judge Cahill scolded the state, when you see stuff like that and you are not an attorney, you may go, that didn't sound like anything. He's like, he said he kind of was nice to him, right? I'm not implying bad faith that you didn't disclose those gaseous lab results. Says, no, I'm not implying that at all. But if you're an attorney, you go, man, they just got scolded, right? Because you don't see that type of stuff. You don't see the judges come out and sort of go, hey, your standard operating procedures are kind of trash. Make sure that doesn't happen again. It sounds like the defense subpoenaed everything and they didn't get everything, but you had stuff that you didn't give to them. Why is that? Maybe you should fix your policies, right? That's a scolding. It didn't look like that if you're a layperson, because it was very nice, right? It's very kind of cordial back and forth, but it was a scolding. And stuff like that, it's like, it's getting close to that line a little bit where you start to ask yourself that question. Did they hold that back for some reason? Why is that? Right? And so defense attorneys, every time this happens, we just throw our friggin' briefcase down. We're like, see what happens? It happens all the time. So we stomp our feet and make a big deal about it. It could just be good faith, right? It could just be them. They got a ton of documents. They've got all of this stuff going on. So maybe they didn't, nobody's ever asked for that. It could have been a good faith oversight. But yeah, the attorneys, you get sanctioned. You get in trouble if you are not acting with candor with the court. Now, the defense, of course, does not have to disclose certain things to the prosecution, right? Like if our client says, something like, yeah, I was digging my knee into his neck or something, and I felt something pop in there. You're not going to disclose that to anybody, right? You have a duty to defend your clients, and I know that rubs people the wrong way, but it's like, there's a rule that says if the government is in possession of evidence, they've got to disclose it to you. It's got to be exculpatory. They got to give it to you. But if you're a defendant, you don't have an obligation to give the government, right? It's their burden to prove you guilty. You do not have to help them do that. You have a right against self-incrimination. And so from a defense perspective, there are some pretty important rules that defense attorneys have. Like if your, client, comes to you and says, hey, I'm going to kill somebody tomorrow, and I want you to help me defend against that. You've got an affirmative duty and obligation to go stop that from happening, right? You got to notify somebody about that. Like you can't, attorney-client privilege can't protect that person. Well, I told my attorney, the attorney called the police. Now I'm mad at my attorney for breaching attorney-client privilege for reporting that I was going to go kill that person. Right? Like the law wants to incentivize attorneys to stop that murder from happening. And, there's also rules about money and holding onto items like murder weapons and things like that. So you can get really down the weeds on all of these issues. But yes, when you're in court, you've got a duty to be honest. And if that comes back down, you could be sanctioned by the court. You could be held in contempt if it was very egregious. You could be charged with a crime if it was fraudulent. You could certainly be disbarred if you are, acting outside of the ethical standards. And so attorneys, it's sort of a self-policing industry. We have bar agencies that govern our licenses and stuff like that. But it's not to say that there aren't bad things that happen in law. I mean, I've seen a lot of it. I've seen a lot of very grotesque operations in place, helping or claiming to help people, but just doing bad stuff, which is part of the reason we started our firm. I was kind of sick of seeing this stuff happening around the country on a regular basis, seeing people get screwed. And I was working at my first law firm, and I just thought, this is not the right way to help people. And so Ryan and I both bailed, and R&R Law Group was born. And hey, I got a pretty good ethical record. Go look me up on the Arizona bar exam. Pretty happy with it. We've got C. Mills says, if the pressure was what caused him to asphyxiate, why aren't the officers that were on his back being tried also? They are actually. So they're going to be charged as accomplices in later trials. Or if the use of force was so unreasonable, why aren't they on trial for not intervening? So yeah, they are. I mean, they are going to be charged. They have already been charged, but they're sort of accomplices to Chauvin. So if Chauvin is acquitted, their charges are going to go away because you can't be accomplice to a non-crime. But theirs are set for later down in the year, I think in November or something like that. So very good questions. Got some good technical inquiries there, and I appreciate that. So all of those came over from watchingthewatchers.locals.com. If you want to support the show, that's the place to do that, and we would be very grateful if you did. All right, and so that's it for that segment.